Welcome to Chapter 3 of Business Laws. Today, we explore the indispensable pillars of contemporary dispute resolution: arbitration, conciliation, and mediation. These mechanisms offer structured alternatives to traditional litigation in our increasingly complex commercial world. As societies and economies expand in complexity, so do the disputes that arise within them. The ever-increasing volume of commercial transactions and cross-border investments has necessitated dispute resolution frameworks that are effective, expeditious, and aligned with international best practices. In the Indian context, the growth of alternative dispute resolution mechanisms has been fueled by statutory reforms and the global push for reducing judicial backlog. This chapter provides detailed exploration of the statutory framework, international conventions, and institutional mechanisms. We will examine these concepts through both theoretical and practical lenses, reinforced with real Indian case examples that illustrate how these mechanisms function in the corporate world. Let us first understand the distinction between dictionary meanings and corporate meanings of our key concepts. This helps managers and leaders appreciate how these processes impact organizational culture, strategy, and long-term partnerships. Arbitration in simple terms. Think of it as hiring a private judge chosen by both parties. It is formal, legally binding, and results in an enforceable decision. For managers, arbitration means predictability, faster closure, and confidentiality. Conciliation is guided negotiation where an independent conciliator helps both parties find common ground. It is particularly effective in preserving ongoing vendor, supplier, or employee relationships by avoiding confrontational outcomes. Mediation is even more flexible than conciliation. Here, a mediator facilitates dialogue without imposing solutions. From a managerial perspective, mediation is cost-efficient, less stressful, and creates win-win scenarios that keep partnerships intact. For managers, entrepreneurs, and business leaders, dispute resolution is not just a legal concept, but a strategic business tool. Disputes are inevitable in any enterprise. How those disputes are managed determines cost, efficiency, brand reputation, and stakeholder trust. Corporate insight. Arbitration resolves disputes by authority, while conciliation and mediation resolve disputes by understanding. A wise manager chooses the tool not only for legal soundness, but also for its impact on people, markets, and organizational harmony. Domestic arbitration is a formal method of dispute resolution where parties, by mutual consent, agree to submit their disputes to arbitrators. In India, arbitration is governed by the Arbitration and Conciliation Act, 1996, reflecting principles of the UNCITRAL model law. The essentials include a valid written arbitration agreement under Section 7, party autonomy allowing choice of arbitrators and procedures, and the final arbitral award, which is binding and enforceable as a court decree. The advantages of domestic arbitration include confidentiality, protecting sensitive business information, efficiency with quicker procedures than court cases, expertise through specialized arbitrators, and flexibility in evidence and procedural rules. One defining feature is minimal court intervention. Courts may intervene only in specified areas: appointment of arbitrators under Section 11, interim protective measures under Section 9, and challenge to awards under Section 34. Case illustration. In ONGC versus Sawpipes Limited, 2003, the Supreme Court clarified the scope of public policy in setting aside arbitral awards. This highlighted how large corporations rely heavily on arbitration and how judicial oversight balances fairness with finality. Managerial takeaway. For companies, domestic arbitration ensures that contractual disputes with suppliers, partners, or service providers can be resolved swiftly and discreetly, keeping operations uninterrupted. The enforcement of foreign arbitral awards in India is governed by Part 2 of the Arbitration and Conciliation Act, 1996. India is a signatory to both the New York Convention 1958 and Geneva Convention 1927, providing international legal basis for recognition and enforcement. Conditions for enforcement include: the award must originate from a convention signatory country notified by India. The subject matter must be capable of settlement through arbitration under Indian law, and recognition may be denied if contrary to Indian public policy. The landmark judgment in Balco versus Kaiser Aluminium Technical Services, 2012, realigned Indian arbitration law with global standards. The Supreme Court ruled that Part 1 of the Arbitration Act would not apply to foreign-seated arbitrations, preventing Indian courts from interfering in proceedings outside India. This brought much-needed clarity and aligned India enforcement framework with international expectations. Effective enforcement instills confidence in foreign investors, ensures reciprocity, and facilitates smoother cross-border transactions. Case illustration: in Renusaga Power Company versus General Electric Company, 1994, the Supreme Court enforced a foreign award under the Foreign Awards Recognition and Enforcement Act, 1961. The court took a narrow view of public policy, paving the way for India's pro-enforcement stance. This alignment with global arbitration practices ensures that contracts signed with Indian entities will not become unenforceable hurdles for global corporations. Conciliation is a non-adjudicatory process where a neutral third party, the conciliator, helps parties negotiate a mutually acceptable solution. Unlike an arbitrator, a conciliator does not decide the dispute. The parties decide with structured assistance. In India, conciliation is governed by Part 3, Sections 61 to 81 of the Arbitration and Conciliation Act. The nature is voluntary, interest-based, and future-focused. It works best where relationships must continue, such as joint venture partners, long-term supply arrangements, franchising, and labor management disputes. Choose conciliation when you need a workable deal rather than a winner-loser verdict. Want confidentiality with minimal media attention? Have multi-issue disputes benefiting from creative trades? Or there is commercial interdependence like supply chains or joint ventures? Avoid conciliation if you need a precedent, a public ruling, or urgent coercive relief, such as attaching assets or preserving evidence. Use Section 9 courts or arbitration for those situations. Under Section 62, conciliation starts when one party sends a written invitation to conciliate, and it commences when the other party accepts in writing. Silence or rejection means no conciliation. Under Section 64, one conciliator is preferred, though parties may agree to 2 or 3 co-conciliators. Appointment can be ad hoc or via institutions like MCIA, DIAC, or industry bodies, ensuring impartiality and subject expertise. Under Sections 67 to 72, the conciliator acts as facilitator, not judge, assisting parties to reach amicable settlement through joint or separate caucuses. The procedure is flexible, not bound by CPC or Evidence Act, with confidential private sessions protected under Section 70. Section 71 requires parties to cooperate by sharing documents, proposals, and experts. Under Section 72, the conciliator can request information and suggest settlement terms. All parties and the conciliator must act in good faith, with apologies and offers encouraged without later prejudicing rights. Section 75 ensures the entire process is confidential, with no recording and private notes. Section 81 makes proposals, admissions, and views inadmissible in subsequent proceedings. The conciliator cannot be called as witness or act as arbitrator in the same dispute under Section 80. Conciliation is a safe sandbox where parties can test options freely. Under Section 73, when settlement appears possible, the conciliator prepares a draft reflecting terms which parties may refine and sign. Section 74 gives the settlement the same force as an arbitral award on agreed terms, enforceable as a decree. Partial settlements are permitted with unsettled issues proceeding to arbitration or litigation. Institutional arbitration involves proceedings administered under rules of arbitral institutions like ICC, SIAC, LCIA, HCIAC, MCIA, and DIAC. International commercial arbitration under Section 2(1)(f) involves at least one foreign party and may be seated in India or outside India. Ad hoc arbitration offers flexibility and potential cost savings, but procedures can stall without admin support. Institutional arbitration provides rules, admin backbone, default appointment mechanisms, emergency arbitrators, expedited procedures, award scrutiny, and transparent fee scales, ensuring predictability and global enforceability. Choosing institutions strategically. ICC offers global footprint and award scrutiny for complex multi-party cases. SIAC provides emergency arbitrator and strong expedited track with Asia focus. LCIA offers robust case management with hourly rate models. HKIAC leads in joinder and consolidation. MCIA and DIAC provide India-based convenience with competitive fees. From a managerial lens, align the institution with your sector, whether infrastructure, technology, or finance. Consider the seat and budget constraints, and evaluate the need for emergency relief mechanisms. Essential elements of an international commercial arbitration clause include clearly naming the seat as legal home and supervisory court, choosing institution and rules, specifying substantive governing law, while curial law flows from the seat, determining tribunal number and appointment method, and addressing language and confidentiality. A model clause reads, any dispute shall be finally resolved by arbitration administered by the chosen institution under its rules. The seat shall be specified city and country. The tribunal shall comprise 3 arbitrators, language English, governing law as specified. Parties consent to emergency arbitrator and expedited procedure where applicable. Under sections 10 to 14, appointment follows party autonomy first, then institutional or court-designated appointment. Section 12 and the 7th schedule require arbitrator independence and impartiality with mandatory conflict disclosure. Section 13 allows challenges for justifiable doubts, with institutions providing faster challenge procedures than courts. Section 19 provides flexibility with tribunals not bound by CPC or Evidence Act, issuing procedural timetables and case management conferences. Interim measures are available through courts under Section 9 even for foreign-seated arbitrations, or through tribunals under Section 17 when seated in India, with emergency arbitrators available pre-tribunal. Section 29A mandates 12 months from completion of pleadings for domestic-seated arbitrations, extendable by 6 months with consent. International commercial arbitrations, seated in India, expect expeditious completion with institutional expedited tracks of 6 to 9 months. Section 31A allows tribunals to adopt costs, follow the event principles with institutional fee schedules providing cost predictability. Section 31 requires written, reasoned awards unless on agreed terms, signed and dealing with interest and costs. Some institutions like ICC scrutinize awards for form and enforceability defects before release. Awards are enforceable as decrees unless challenged under narrow grounds in Section 34 for domestic seats or Section 48 for foreign awards. Fast-track arbitration under Section 29B is designed for efficiency, typically concluded within 6 months. Proceedings are largely document-centric, minimizing oral hearings, with arbitrators deciding based on written pleadings, documentary evidence, and submissions. This approach is cost-effective, time-bound, and well-suited for straightforward disputes. Online arbitration introduces e-arbitration where the entire process, notice, filing, hearings, occurs through secure virtual platforms. Post-pandemic realities accelerated adoption, aligning with Digital India initiatives. Advantages include lower costs, access for geographically distant parties, and faster turnaround. Concerns include data security, authentication of digital evidence, and enforceability of online awards, which continue to be debated in domestic and international legal circles. However, the benefits for corporations include saved travel costs, cross-geography dispute resolution, and seamless adaptation to remote first-work cultures. Case illustration: the Delhi Airport Metro Express, Private Limited versus DMRC 2017 arbitration showcased how time-bound processes prevent infrastructure disputes from dragging indefinitely. While not purely online, the case emphasized efficiency principles driving digital arbitration today. The Mediation Act. 2023 is India's first comprehensive statute for mediation. It promotes institutional mediation, validates online mediation, recognizes mediated settlement agreements as directly enforceable, and establishes professional standards through the Mediation Council of India. The Act applies where mediation is conducted in India, covering disputes where both parties are in India, international mediation with at least one foreign party in commercial disputes, and disputes involving government or government-controlled entities, especially for commercial matters. Mediation must be completed within 120 days from first appearance before the mediator, extendable once by up to 60 days with parties' consent. The conduct is flexible and party-centric, with mediators not bound by CPC or Evidence Act, protecting voluntariness, confidentiality, and self-determination. The mediated settlement agreement is final and binding, enforceable as if it were a court judgment or decree under CPC. Challenge is limited to fraud, corruption, impersonation, or non-mediable disputes, with only 90 days from receipt for challenge. Optional registration provides record-keeping with unique numbers. To summarize the process flows, arbitration moves from dispute notice through tribunal appointment, hearings, to binding award and enforcement. Conciliation flows from written invitation through joint caucuses to settlement agreement with decree-like effect. Mediation proceeds from intake through facilitated sessions to MSA with court judgment enforceability. The strategic choice depends on dispute nature. Arbitration for high-stakes complex conflicts requiring binding verdicts, conciliation for relationship preservation with creative solutions, and mediation for flexible win-win outcomes. Consider relationship importance, urgency of resolution, confidentiality needs, and enforceability requirements when selecting the appropriate mechanism. For business leaders, these mechanisms are not just legal concepts, but strategic business tools. Effective dispute resolution determines cost efficiency, brand reputation, stakeholder trust, and long-term partnerships. The choice of mechanism should align with business objectives, relationship dynamics, and organizational harmony. In conclusion, arbitration, conciliation, and mediation represent the evolution of dispute resolution in modern India, aligning with international best practices while serving domestic business needs. Understanding these mechanisms empowers managers to make informed strategic decisions that protect business interests while preserving valuable relationships. Thank you for your attention to this comprehensive overview of Chapter 3.